There is no law in subtitle C that requires the withholding of an employment tax. Why do you think that is?
Because it's voluntary.
Well, why is it voluntary? Why isn't it required? Why can't they pass a law requiring the withholding of an employment tax?
It would be unconstitutional.
Be unconstitutional. Why is that, Gil? Why would it be unconstitutional for having a law for requiring the participation in Social Security?
Direct taxes have to be apportioned.
Well, that's right. Direct taxes have to be apportioned. That's correct.
Voluntary servitude.
Huh?
Involuntary servitude.
That's right. Well, the whole thing flies in the face of the Constitution because it's socialistic. The basis of it is socialism. You take from him and him and him, and you put it in the pot and give it to him. And the government participates in that. That's socialistic. That's socialism, pure socialism. The Constitution is anti-socialist. It protects private property where it can't be taken from him and given to him. So any law that's passed that authorizes the taking of property from him forcibly and given to him would be what? It flies in the face of the Fifth Amendment. You can't take somebody's property and give it to somebody else.
But they're doing process.
No, they're not doing it. Who said they're doing it?
They're volunteering.
You're giving it.
You volunteer.
How can you volunteer if they take it away from you before you get paid?
No, you volunteer.
When you got the number.
That's what we're getting into now. I'm showing you. You volunteered. They didn't. There is no law.
When you get hired by an employer, they shove that paper in your hand and say, here, so you can get paid.
But there is no law requiring that. You do it.
Because they tell you to do it.
Well, but that's absent of law. That's absent of law. Why do you think they need? All right, let's get to that piece of paper. I want to show you this. You have all the subtitles again, and here you have subtitle C. Here's your chapters in subtitle C. See it? Chapter 21 is Federal Insurance Contributions Act. Chapter 20, the Railroad Retirement Tax Act. 23, Federal Unemployment Tax. 24, collection of income tax at source on wages. That's interesting, isn't it? Here it's saying that we have an income tax. Where?
Subtitle C.
In subtitle C. We'll get the exam. We have to look at that one carefully, won't we? Here's chapter 25, general provisions relating to employment taxes. All right, so we're going to go to 24, collection of income. That's where we want to go, right? So where do we want to go? 24. In 24, we're going to go to the collection. Does anybody know which code section that is? Collection of income tax on wages.
27? 32. 3204? What? 3204?
No.
Did you say what section?
Yeah, what section is that, do you know? You know what section that is? Anybody know?
What's the question again?
What section is it, withholding of income tax on wages? What code section? And what chapter?
Tax on wages.
What chapter is it?
24?
24, we just showed it to you, right? Chapter 24. Right? Do you recall? Now, do you recall back when we were looking at 7701A16? Remember that? And we had some code sections that begun with what? 14. And we have some that begun with 34. Right? And we said all the code sections with 14 are in chapter what? Anybody remember?
6.
No, what chapter are all the code sections beginning with 14?
3.
Chapter 3. And all the code sections beginning with 34 are chapter what? 24, which is income tax on wages, right? Okay. But in order for us to understand chapter 24 and that section that deals with that, we have to go to subtitle F. Which subtitle F again? Procedures and administration, right? They implement the other categories. All right? And where we go to section 7806. In fact, before you read any other code section in the whole Internal Revenue Code, you have to read section 7806 first, or you'll never understand the Internal Revenue Code. Why is that? Because that is the construction of title. That's how all the code sections are constructed. It tells you, right? Cross-references. The cross-references in this title, which is all of Title 26, right, to other portions of the title or other provisions of law where the word "see" is used are made only for convenience and shall be given no legal effect. Right? Now let's go to B, which is really more interesting. Arrangement and classification. No inference, implication, or presumption of legislative construction shall be drawn or made by reason of the location or grouping of any particular section or provision or portion of this title, nor shall any table of contents, table of cross-references, or similar outline analysis or descriptive matter relating to the contents of this title be giving any legal effect. The preceding sentence also applies to the side notes and tables contained in the various prints of this Act before its enactment into law. So that means when we go to section what section it is? Anybody thought of what section it is yet? 3402. Before we get to section 3402, it says this is the title, right? Income tax collected at source. Is that the code section? No, it's the title. It's given no legal effect. Well, where's the code section start?
The word accept?
With the small a. The code section starts with the small a. It doesn't start right there with the title. The title means nothing. In fact, in this case, it was put there deliberately to do what? To mislead. Particularly when the definition of wages and employment and all the rest of them are found in Title 20 and not found here. So it's put there purposely to mislead. You follow that? Again, you can give no other conclusion, come to no other conclusion except it was put there to mislead. And no, anywhere you look in here, generally except as otherwise provided in this section, every employer making payment of wages shall deduct and withhold upon such wages a tax determined in accordance with the tables of computational procedures prescribed by the Secretary. Any tables, etc., etc., etc. And it goes on to say that he needs a what? A W-4. What is a W-4?
Permission for him to withhold.
Here is a W-4. What does it say? It's an employee's possessive S, right? Withholding allowance certificate. What does the words mean when you use them in the English sense?
Permit?
It's permission to withhold. So without that W-4, he cannot withhold any wage tax in Subtitle C. In order for you to fill out a W-4, you have to have what?
Social Security number.
If you don't have a Social Security number, you cannot even fill one out. Now, because he needs a W-4 to withhold, that means that you can have a number and what? And not be required to use it. In fact, the law says very clearly you have no obligation to give that number to anyone, including government agencies, including the Internal Revenue Service. A few hours ago, we looked at section 6109 and notice 609. Recall that? Remember 6109? And what did 6109 say? Does anybody remember what 6109 said?
Had to use your Social Security number on any returns you were required to file.
That's right. If you file a return, you have to use the number. It doesn't say you have to use the number. The IRS, you're required to use the number. It says that if you file a form, you got to use the number, is what it says. Very clear.
If a person doesn't sign the W-4, does the employer then not have to send out a portion? I mean, don't
The employer has no authority to take his money. It would be the crime of conversion.
But that wasn't my question. Like,
Well, that's an answer to what you were asking.
well, what I was really trying to say that I wasn't making myself clear.
But I understood you. But go ahead.
Bless your heart. What I'm trying to say is, like, years and years ago, when I lived in the South, which was a long, long time ago, and I had some help in the house, I was told I had to take out and then pay the same amount out above withholding. In other words, if I took out $10, I had to send in an extra $10.
You were an employer, you mean?
That's what, yes, that's what I was told.
Well, that's right. An employer will match what he takes from the
But
employee.
if you don't take, then if a person doesn't give you this W-4, then the employer has no responsibility. Is that correct?
He has no requirement or authority.
He doesn't have to send in a...
No, he has no authority. If he takes the money without a W-4, he committed the crime of conversion. You know what the crime of conversion is, don't you?
Taking from converting something belongs to someone else, and
For an unauthorized use. Conversion is when you take something that belongs to someone and you use it for other than its intended use, for an unauthorized use. So if you have my wages, which are due me, because I gave you the hours that we agreed upon, and if you take from my wages a portion of them without my authorization of a W-4, then that's the crime of conversion, because you converted that property to an unauthorized use that I did not authorize you.
If you do not withhold from the employee, do you then have to send in your portion of that $10?
Of course not. You have to withhold. He has to give you permission first, or else there's no portion to send in. Without one, there is
his or yours.
without one, there is no other.
okay. Well,
I mean, that's,
well, then, not so. So is there? Did she really commit a crime?
there is no crime.
So that was just a whole lot of to do then.
Well, for the benefit of the public.
Well, I think that hers was dealing with an alien, the person.
But the alien was working.
Yeah.
But if it's not been an alien, then she really
She was
wasn't.
working here.
Yeah, but she was a font. It was something about.
But it's still Social Security. There's a requirement to withhold income tax from an alien.
Yeah, but I think that what my understanding of what happened in that situation was that she was a alien that had come into this country.
Yeah.
She would be required to have a Social Security number.
Then she has a requirement to have a Social Security number, but nobody's required to use it. All right? See, they have a requirement to withhold an income tax from an alien. Nobody's required to participate in Social Security, even if you have a number.
But
Yeah.
she should have asked her then if she wanted to participate.
No, that whole thing was done, in my opinion, for whatever that's worth, that was done for propaganda purposes for the public. To continue this Oz-type atmosphere involving taxes.
Well, I got a question.
Okay? Smoke and mirrors, my dear.
But it's really hurtful.
I got a question. If a person wanted to, if he had a withholding agreement with his employer, and he wanted to withdraw that,
They're good for 1 year.
okay.
And it goes the same way as an affidavit of revocation and rescission.
So every year you would have to do
Every year you have to give a W-4.
Okay, now, what I'm saying is, so a person stops paying into the Social Security system for those who have been paying it for years. Would that eliminate them from any sort of benefits in the future?
Well, what it would do, if they build enough credits, they would get the benefits for those credits. But they contend that the purpose of applying for the number is to obtain and retain benefits. Obtain and retain benefits. Now, whatever that means.
Yeah, that's what I was going to say. That's gobbledygook.
Yeah, whatever that means. So, if you, I've never looked into the Social Security law as far as getting benefits. I've never participated in my life, but maybe a month or two, really. When I was on the police force, we didn't participate in Social Security. We had our own pension system. And I didn't work in the workplace but a year or two where I had it withheld from me. And after that, I went into business for myself, and that was it. So I didn't build enough credits, and I have never bothered to look into the code sections involving retaining payments of benefits. I know full well that they can stop Social Security any time they please, and you cannot object to that. You have no standing to argue with it. They can end Social Security tomorrow and don't have to justify it to anybody.
And you won't get any of your money back either.
Oh, no, well, no, you don't get any money back at all, no.
So is the procedure not to fill out the form at all, or to write exempt and fill out the form and sign it?
Well, if you're saying you're exempt from what?
Well, it says, I claim last year I had a right to a refund, et cetera, et cetera. But you have no
When you put exempt on there, what are you saying you're exempt from?
taxation.
What taxation?
Whatever.
How many categories of taxation do we have now? Let's go back. Everything. If you apply the code generally, you're going to get in trouble, right? That's why we're dealing in terms and code sections. Remember, law is words and legal terms. Law is semantics. You know, I can say to you, we're a First Amendment organization, and I can't advise you to do anything, and they can't do a thing to me for that. If I turn around and tell you, you don't have to do this, you don't have to do that, you don't have to do this, and advise you, you don't have to do this and do that, then they can put me in jail. Just that simple. Law is semantics. You've got to be careful what you say. That's why we instruct everybody who comes to work here, you do not run off at the mouth loosely over the telephone. In fact, we even have all the people who work here to sign policy agreements. And making it very serious to them, because if they do these things, they're on their own because they've been instructed not to. And if you call here, you won't get them to tell you one blessed thing on how to do anything, because they won't advise you. They'll tell you facts about the law, which is all we do here, is talking about facts about the law. Nothing else. See what I'm saying? So terms are very important, right?
You said an employer's required to have you fill one of them out every year?
No, the employer is required to ask you for one. But nobody is required to give anything.
Then how can they withhold it?
See, they tell the employers that they are required to ask and get, but that's not right. The law is very clear that the employer, because of the voluntary application for his number, they have a right to regulate him to a certain degree, because he is collecting taxes for them, and for that reason they have a right to regulate him. And one of the things they tell him is a requirement is that he has to ask for a Social Security number. But the law very clearly says that nobody's required to give it, and the employer, when he's refused, he writes the IRS and tells them that, and then his obligation ends, according to the law. Of course, the last part of that, they don't tell the employer. CPAs and tax attorneys tell them just the opposite. They tell them they have to get it, which is a lie, a downright lie, because there is no requirement. They tell them, well, if you don't get it, it'll be a penalty. But when you go to the penalty section, it says there is no penalty for not getting a number. So the law is altogether different from what the mindset of the so-called experts who call themselves CPAs and tax attorneys, right? By the way, that fellow who wrote us a letter that I showed you a little while, he was a tax attorney. He said he learned more from our article in the newsletter than he did from the law journals. You know. So anyway, but they don't know. IRS has workshops for them, and they tell them all these things that are not so. But there's no requirement, no.
So if I don't fill one of them out every year, then they can't withhold it?
They're not. No, the law doesn't. When they withhold, it's a crime of conversion. So your property is being converted. But getting back to what this gentleman said, which is very important, what does it mean if you put the word exempt on there? It means you're exempt from what?
Federal income tax.
The federal income.
Wage tax.
Does this deal with the federal income tax?
Probably has to research that OMB number.
Well, when we search the OMB number, what do we find? It pertains to what code section? Well, it's subtitle C, but what code section? 3402, the one we just saw. This pertains to 3402. It doesn't pertain to subtitle A at all. It wouldn't. Because this is permission to withhold. In subtitle A, there's no permission, there's a requirement and an authority to withhold. You see what I'm saying? Subtitle A is imposed by law. Subtitle C is totally voluntary, except for the requirements put on the employer to ask for numbers and to turn the money in. But that's only the employer who says, I want to participate, and when I want to participate, then I'm going to come under your rules to participate. And most employers participate. Why? Because the lawyer or the CPA that set them up told them they have to get a number. In fact, most of them make out the application and say, here, sign here. Right? I didn't make any application for a number. Are they coming in here and telling me I have to withhold? No. Why not? Because the law doesn't say I have to withhold. And they know it.
Is it unlawful for an employer to refuse an employee or fire him, so to speak, or refuse employment because he refuses to fill out?
All right. Now that's a good question. But before we get into that, let's finish his. We're not finished his yet. When you put exempt on there, what are you saying?
My understanding is that I'm just saying I'm not liable for any federal income tax.
No, that's not so. It doesn't go to subtitle A at all. It only goes to subtitle C, and it goes to section 3402. That's what W-4s are used in conjunction with the OMB control number. When you chase it at 0010, that's where it goes. It's subtitle C. All right. When you go into subtitle C, what it's saying, it's authorization. So when you put exempt on there, you're committing a crime if you're not a student.
When you when you use a term on a legal document, you have to use the definition of that term.
That's right. That's right. A student is exempt. And a student would put exempt on there because a student, under the Social Security Act, can get benefits before building credits. A student can get a benefit to go to school in the beginning and be exempt from building the credits. They're allowed that within the Social Security Act. If you put exempt on there and you're not a student, then you're telling him you can withhold, but I'm exempt from the withholding. And you've committed perjury because you're not a student. A person, which we'll show you in a minute, a person claiming not to be subject to withholding of income tax, what do?
Not fine.
Well, no, they do something. A person claiming not to be subject to withholding of income tax, according to the law, what do? Huh?
Statement of citizenship.
They give a statement of citizenship. We'll show you that law in a little bit. All right, now everybody understands what happens when you put exempt on here, right? You get into trouble because you've committed fraud. Okay? That's why they call it a fraudulent W-4. You don't want to do that. Everybody understand that now. Now we'll get into your question and repeat it again.
If an employer refuses employment to
A person because he doesn't give a Social Security number.
because he refuses to fill out a W-4 or fires him because he refuses to fill out the W-4, is
All right.
that unlawful?
Under the Constitution, it is not unlawful because an employer can contract any way he wants. I can make, under the Constitution, I can make any condition on you whatsoever that I want to make on you, and you have to agree or else you don't have to be employed there. Okay? So under the Constitution, that is not unlawful. See, we have to deal with this all the time, and that's why people don't understand how delicate that is. But under the Civil Rights Act of 1964, it's unlawful. So what does that say? Now let's think about that one, huh? Huh? Now let's think about that one, huh?
Then the Civil Rights Act is partially unconstitutional.
In construction, that is correct.
Well, it's not a law.
Huh?
That wouldn't be a law. It's against
But it hasn't been overturned yet.
public policy.
It's public policy. But under that act, you can move against them, and we have. You can do it on two grounds. Under the Civil Rights Act of 1964, it is unlawful to what?
Discriminate.
Against who? For what? Who knows? You ought to know. You ought to, what is it? Huh? What is it, David? Discriminate against because of race, religion, national origin, disability, right, right? Race, creed, national origin, disability, right? So what are we dealing with here?
National origin. Statement of citizenship.
And also, what other one? You could deal with two things here. Religion, that's right. It's illegal to discriminate because of national origin and illegal to discriminate because of religion. You can take a religious objection to participating in Social Security, and they can't discriminate you for that. In fact, we had a person fired in Dallas, Texas, and he went to the Justice Department and made a complaint, and a young lady attorney there prosecuted under the Civil Rights Act of 64, and they had to rehire him and give him all his back pay. We have a case in here, everybody wants to see it. Now, the same thing goes for national origin, but they're a little reluctant to take up national origin. But it's the same thing. Well, how would it be on national origin now?
Because we're citizens of this country.
Well, why? How would that relate? I mean, if we're going to go into court, we're going to argue a law, there has to be some basis for the argument.
It says if you want to be exempt from the withholding, you supply a statement of citizenship.
That's income tax. All right, that's income tax. Now we're talking about Social Security numbers, being hired and not having a Social Security number.
Oh, not having.
Employment taxes. See, don't mix employment and income taxes. You can't mix them. The employers do that, and that's the problem. All right? Now, we're talking about national origin. How does that apply, national origin?
Because the citizen's not required to get a Social Security.
Because an alien has to have a number and a citizen doesn't. So if an alien has to have the number, then the employer is discriminating because he's saying you have to have a number like the alien. And because of your national origin not needing the number, he's discriminating against you. Now, the Justice Department doesn't want to argue that. Why is that? They don't want to bring no attorney working for the government wants to be the one to bring the house of cards down. It's one thing to say that you can object for religious reasons, right? It's another thing to say national origin because, boy, that's the whole ball of wax. But if now let's examine religious reasons. Let's go to religious reasons. What does that mean if I allow you to exempt yourself from participation in a program because it's religious? Hypothetically saying it's imposed by law, which we know it isn't, but let's consider for argument purposes that Social Security is imposed by law. And being as such, I allow you to opt out because of your religion, and don't allow me to opt out because of my religion. That's how they try to get it. Because they say that they're the ones who say if you have the right to, and really they can reject your application for religious reasons. That's what the law says. So if that's the case, would that be in violation of the Constitution? What provision of the Constitution?
Equal protection under the law.
Huh?
First Amendment?
No.
Free exercise? Fifth.
Equal
No,
protection under the
no,
law.
not the fifth. What part of the Constitution would that be in violation of?
Separation of church and state.
No.
No, that's not
What's
right.
first?
That's not.
No, what would it be in violation of?
Equal protection under the law.
What is that? Amendment what?
14.
14. Equal protection of the law. I would be not being denied equal protection of the law. Isn't that correct? That shows you how this thing is. I mean, it's so rotten. It's rotten to the core. It's a contradiction, right? You know, we had that little thing that Sally brought in here. It was supposed to be a quote from Clinton that we put up before the meeting started. And what he said is totally correct. It's totally correct. If we want to be free, then with freedom comes responsibility. If we're not going to be responsible and deal with one another as individuals and treat one another justly, then we cannot be free. It can't be. You cannot have a crooked society and cheat one another and not treat one another fairly and be free. It's one way or the other, and we got to understand that. Through our wealth, we have become materialistic to the degree that we cheat one another. And in that, we enslave ourselves and bring about these very conditions that cause the enslavement by our own actions. Everybody understand that? So we have to examine ourselves. You know, the first place I look at is myself. I want to be my own worst critic. Because when I'm my own worst critic, I have to what? I have to improve. Right? When you're your own worst critic, you have to improve. If you don't, then man, you're a poor critic. All right. Now, we're going to add a little proof to this. Let's say that I'm employing you and I hire you on and I have made an application on an SS4 form and I got a EIN number and I ask you for a Social Security number. You say, yeah, man, I want the whole ball of wax. I want to participate. You give me a W-4. I withhold from you for a full year. And at the end of the year, I give you a W-2. The W-2 has your full earnings on it. It has your total deductions. All right, I take and then you take the W-2 and you use it to compute a tax on a return. You enter the amount of tax due. You take and you attach the W-2 to the return. You mail it to the service center with payment or whatever of the amount of tax you say that you owe. And the service center receives it. The examination branch looks at it, and they make a determination that there's more tax due than what you entered on the return. The question is, can they send you a notice of that deficiency? Huh? Can they?
No.
You say no, he says yes.
They don't have the authority to alter that form if you sent it in.
All right. How many hands say that they can send a notice of deficiency? Raise your hands. Everybody says they can send a notice of deficiency. If they can, in that case, you know, you send in your return, you attach a W-2 to it, and you send it to the service center, and they say, well, no, we examined it. There's more tax due than what you have on the return and what you paid. That makes the return deficient, right? Can they send you a notice of that deficiency? How many hands say yes?
That's for people filing a 1040?
Huh?
If they file a 1040?
If they filed a 1040,
I say yes.
you say yes. How many we have here? 1, 2, 3, 4, 5, 6, 7, 8. 8 people, 9. Who else? Anybody else?
Get in while you can.
Get in while you can. You're all wrong. You're all wrong. David, I'm going to talk to you Monday morning. All right, here we go. Notice of deficiency. This is what they're authorized to send that deficiency, right? In general, if the Secretary determines that there is a deficiency in respect of any tax imposed by A, B, or chapters 41, 42, 43, or 44, which are where? He is authorized to send notice of such deficiency to the taxpayer by certified or registered mail. Now, what is that saying? No, you can't, right? Why is it saying no, that they can't send you a notice of deficiency?
Because C is not there.
C is not there. W-2s, W-4s go to C. C is not authorized because C is not imposed by law. It cannot be authorized. What is the requirement to file a return? Subtitle A. Did you see C in the requirement to file a return? No. There can't be any requirement to file a return when it's not in the subtitle of tax is not imposed by law. It can never be in C. Not unless the Constitution is done away with. C is totally unconstitutional. That's why it's voluntary. That's why the IRS says it's voluntary compliance and self-assessment. Because the citizen is not the subject of the tax code. There is no withholding in the tax from citizens. It doesn't exist. That's why a citizen gives a statement of citizenship so they can inform the withholding agent he's not subject to withholding. Everybody understand that? Is it clear? Remember that tax expert that the IRS put on Zoe's show? Right? She was going to really show everybody all about why we're wrong. And we called in and we said to her, can you tell me how many chapters are in subtitle A? What did she say? She says, you have the book, you tell me. And she didn't even know. I said, well, there's 6. I said, now can you tell me where in those 6 chapters, income tax, do we find withholding on citizens? Silence. Let her hang, right? Then we said to her, well, do you know? Silence. Let her hang a little more. Then we said, well, there is none. It's not there. There is no withholding on citizens anywhere in the code. She didn't rebut it. She just kept quiet. The IRS didn't come out and say we're wrong. In fact, the IRS wrote a letter to a senator, right, Frank, and said what a wonderful job she did. If that's the best they have, man, they're in trouble. And believe me, they're in trouble. Okay, now that leaves one other thing, which is called self-employment. We didn't cover self-employment, did we? You work for yourself, and they send you a bill and say, this is self-employment tax. All right, it's an employment tax. It means it's what? If it's an employment tax, it means it's what? No, if it's an employment tax, it means what type of tax is it?
On wages, so she can pay somebody.
If it's an employment tax, what type of tax is it?
Business.
The Social Security tax. All right, an employment tax is a Social Security tax, right? But this is a self-employment Social Security tax. Where is self-employment Social Security tax? Can they tell a person to withhold the tax from himself? Can they tell him to give himself a W-4? Can they? I'm in business. Are they going to contact me and say, give yourself a W-4? No.
You're supposed to ask yourself.
Oh, you're supposed to ask yourself. See, that was a problem. That was a problem they had. They had a problem with people who worked for themselves. And they said, now, what are we going to do about this problem? Remember that? Yeah. I mean, Social Security came, and all of a sudden they said, well, we got to do something with these. We got to have a self-employment tax. Remember when they passed that? It wasn't that long ago, about 30, 40 years ago. Right. So anyway, so they passed that. Is that in subtitle C? No, if they put it in subtitle C, how could they do anything with it? They couldn't do anything with it in subtitle C. Where did they put it? Anybody know where self-employment tax is? Subtitle what?
Subtitle A.
Subtitle A, what chapter? Self-employment taxes. It's in subtitle A, section 1401. Isn't that interesting? Now they have you in subtitle A, right? And you're a self-employment individual. Isn't that interesting? What does it say here? There is imposed, now they're imposing it. They're imposing the tax by law in subtitle A. There is imposed, in addition to other taxes, a tax upon the self-employment income of every individual. Man, here they're laying it right on you. They're laying a Social Security tax on you, which you know would be unconstitutional, wouldn't it? Isn't that right? But here they're laying it on you in subtitle A. The same prescribes in 1401 old age survivors disability insurance and hospital insurance, right? See paragraphs 1 and 2 of paragraph B of this section. This tax shall be levied, assessed, and collected as part of the income tax imposed by subtitle A, right, of the code, except as otherwise expressly provided, will be included with the tax imposed in sections 1 and 3. If it's imposed the same as sections 1 and 3, how's it imposed?
6012?
No, that's a requirement to file a return. If it's imposed by sections 1 and 3, how's it imposed? No, it's not voluntary. It's imposed by law.
Tax treaty.
That's right, tax treaties. Foreign earned income.
Foreign earning.
It's a foreign tax. You've got to be in a foreign country to pay it. Aren't they slick? Huh? In section 1, it's foreign earned income. We just went through that, right? Huh? They're pretty slick, aren't they? So, yeah. So here they put it.
But it also says shall be levied, assessed, and collected.
Right.
Who's going to do that?
Huh? Who's going to do it? You have to pay it yourself.
But it doesn't say for me to levy it. It says this tax
Shall be levied by every individual in a foreign country. You report it on the return. Huh?
Could you give an example so we can see this? Could you,
Example of what?
that is?
Who that is? It's every person who is self-employed working in a foreign country. Has a tax treaty with the United States. Sure. Right. Everybody understand that? Huh? It's foreign earned income. Likewise, if the taxpayer engaged in trade and business in selling property or installing plans, provisions of 430 to use installment method, where is it at here? Computing income purposes of tax under sections 1 and 3, and must use the same method to determine the earnings of self-employment income. See it? You use the same provisions as 1 and 3, which is foreign earned income. Right? This is 1402, computation of net earnings of self-employment. It tells you how to do it and use the same as 1 and 3. So it's applied the same way. All right? Everybody understand it?
Could I ask a question? What do they do about this if you sell your house?
We have people call us all the time. We say, I'm at a settlement. Members, you know, I'm at a settlement, and they won't settle without me giving the number and filling out these forms you're talking about. And we say, fine. You just tell the lawyer, I'll stay on the line, I'll hold on while you tell him, that if he doesn't settle this, that you're going to sue him for breach of contract, for abridging a contract. Because the party who's buying is there to settle. I'm selling, I'm here to present a clear title and settle, and he's interfering with that. He's abridging a contract which is against the law. and we're going to sue you. And without fail, every time, you know what they do? They settle without the number. We've never been refused.
I'm so glad I asked you that question.
You see, there has to be authority and there has to be law. If people say you got to do this and you got to do that, and you say, okay, I'll do this and that, then what are you doing? You're just doing this and that, and you don't even know why. And you assume that they're correct. You know, we know these people that run our government. They know everything. Ask Sam Nunn. Right?
Well, it's only in the last, 5, 6, 7 years that they've started this, so whose great idea was that?
Why do you think there's such a campaign to get everybody to get that number and use it? When I was a young man, I could open an account. Nobody thought of asking you for a Social Security number. Huh? When we first got married, nobody asked you for a Social Security number. Nowhere. For anything you wanted to do. Well, why all of a sudden they're asking for this?
They're doing it in the hospital since the babies are born.
They're telling you to apply for one. Well, why do you think that?
Well, I've been...
No, why do you think that they... Because the IRS cannot even open a file with your name in it without that number. They could never write you a letter unless you had that number. You understand what that is? That's freedom. They can't even write you a letter. Well, what does that tell you? They have to have that number. When we correspond with them, Phyllis, do we have to have that number? Huh? Without that number, they won't even talk to us, will they? That's why they're pushing for the number, because without the number, the whole house of cards falls. The Federal Reserve can't operate. Nothing can work without that number, except our freedom, if we're responsible enough to keep it. Now I want to show you a letter that was sent in by one of our members that was received back in 1988. And it was from Penny Payton from the Social Security Administration. And she says some very revealing things in this letter, such as, Social Security is a voluntary system in that no one is required to get a number. And then it goes, however, programs which use Social Security numbers for a control process might not allow a person without a Social Security number to participate. The Internal Revenue Service uses Social Security numbers as taxpayer identification numbers. So notice the distinction there, that they use them as taxpayer identification numbers. It doesn't say they're required, you see. And look here, a person with no Social Security number would have no taxable income. Isn't that interesting? A person without a Social Security number would have no taxable income. You know, just a little while ago, I told you and showed you that if you had never made an application for a Social Security number, the Internal Revenue Service could never have set up a computer file. See, it's verified in this letter by Penny Payton. Interesting, isn't it? We have one of our associates here has been going down to the Library of Congress and digging into the archives down there, and he opened up boxes that you wouldn't believe on the forming of the Social Security Act. All the letters from the Secretary of the Treasury and all the congressmen and all that were involved. And you ought to see the gems that he's been pulling out of there. I mean, the original onion skins that have never been touched for all these, what is it, now it's 60-odd years. 60 of the boxes had dust all over them. And well, as soon as he told me what he was doing, I told him to go back there immediately. That's the only reason why I'm talking about it now. I said, go back there immediately and get them certified with a seal of the Library of Congress. Even though they put the stamp on each individual document when they copy it, where it comes from, you still go back there and get that seal. Because if he doesn't go back and get the seal, they'll all disappear. And then they'll dispute where they come from. Everybody understand that? Every time we go into court, we get everything that we use as evidence certified, so that there is no argument where it came from. Everybody understand? So he brings them up here now, and he's got a stack like that, and there's a red ribbon goes through all of them. They're all numbered, and on top there's a great big certificate with a large red seal on it from the Library of Congress. Nobody can dispute any of it anymore. But we find that very interesting, and all she's doing is verifying the things that we've been showing you here tonight. Now, we're going to look at the application that's made for the SS4 form. You know what the SS4 form is, right? Everybody know what that is?
EIN?
Yeah, that's for an employer identification number. Usually if somebody goes into business, they usually contact a lawyer, an accountant, or a CPA. And the CPA, the lawyer, or the accountant will either tell them, well, you have to get an employer identification number, or else they'll just say, sign here and fill it out for them and send it in. I mean, it happened to me years ago when I started a corporation as a building business. They got my corporation, this lawyer who set me up, got the corporation an EIN number. But here we're going to examine the form that is used. And in particular on that form, we're going to examine line 12. It says, if the business has or will have employees. Now everybody remember what do we find out what employees were within the Internal Revenue Code? What are employees within the Internal Revenue Code?
Covered.
No.
Those covered by Social Security?
Covered, right? Those covered by Social Security. So employees, as defined within the code, are those employees that are covered by Social Security. In order to be covered by Social Security, you have to first make an application for what? A Social Security number, right? All right. Well, employees enter in this line the date on which the business began or will begin to pay wages. Now, anybody remember what wages were? It's another legal term. Anybody recall what wages are? What's the definition of wages within the Internal Revenue Code?
Isn't that what
Paid
you used to
covered
do?
employee. Payment to a covered employee?
Well, yes, but it's remuneration paid for Social Security purposes. That's what wages are. Remuneration paid for Social Security purposes. All right? To the employees. Well, that makes sense. If they're covered employees by Social Security and you're paying remuneration pay for those purposes, right? If the business does not have any plans to have employees, enter NA in this line. New withholding agent. Enter the date you began or will begin to pay income to a non-resident alien. Now, can anybody tell me the distinction between an employer and a withholding agent? Is there a distinction? Is there a distinction between an employer and a withholding agent?
Yes.
There is? What is the distinction between the two?
The distinction is that an employment agent is dealt with in Subtitle C, and a withholding agent is concerned with the Subtitle A.
In other words, what you're saying is that an employer will withhold taxes under the provisions of Subtitle C. Is that correct?
Correct.
Okay. And a withholding agent withholds taxes under the provisions of Subtitle A.
Correct.
All right. What are the subtitles?
Subtitle A and Subtitle C.
All right. Well, what are they? What kind of tax? Are they both the same kind of tax?
Subtitle A deals with income taxes, and Subtitle C deals with employment taxes.
Yeah, that's correct. So they're two different taxes. They're not the same, right? Okay. But most American citizens and most employers believe them to be the same thing. Right? Remember that? We went over that just a little while ago. Okay. Now, let's go look at the front of the form itself. see what it has to say. Notice at the top, you put in your name of the applicant, etc., right on down. And it talks about if a corporation, give name of foreign country, right, foreign country. See it? And we come on down here to line 12. First date wages or remuneration paid or will be paid. Note, if applicant is a withholding agent, enter date, income will first be paid to who? The non-resident alien. It doesn't say U.S. citizen, does it? Huh? So a withholding agent withholds from who? I just asked a judge in court just Tuesday before last. Can you show me in subtitle A the withholding of income tax from United States citizens in the states of the Union? And he refused to answer. He just refused to answer. Isn't that interesting? Where is it, Judge? And he just refused to answer. That's the biggest problem we have, you know, is these judges are refusing to accept the truth or acknowledge it or admit it. One of the three. But anyway, we can see that there is a difference between a withholding agent and an employer. Now, would a withholding agent have to fill out this application?
If he had non-resident aliens working for him.
They?
Yep.
Who is it?
Yes.
Oh, okay, right. If he had non-resident aliens working for him.
Yeah, that he was required to withhold taxes.
Oh, those here on a temporary visa.
Now that's a question.
Well, is that correct?
Green card.
If they have a green card, what are they? I understand it's no longer green, it's another color, but they still... It's pink, yeah.
It's actually pink.
Yeah. They still call it a green card. If he has a green card, what is it?
It's a resident alien.
A resident alien.
Okay. Non-resident.
A non-resident, so he would have to be here on what, a temporary visa? With a working permit. Right? But would the withholding agent deal with him? I guess he would. But would he need a number to do that?
No.
Yeah.
He would.
They would have nowhere to report it.
Well, I'm sure he can report it.
Private number?
Sure.
Non-resident alien would need a number, but not the withholding agent himself.
That's right. The withholding agent doesn't need a number. If he would have needed a number, then there would be a law requiring the application for a number. There is none. At least not to my knowledge. I've been asking the IRS to show it to me because I don't want to be outside the law, and they haven't showed me any. And we've been asking them for a long while because I never made application for one. I said, if I have a requirement to make application for one and withhold, will you show me the number? And as of this date, they haven't shown me any law requiring me to get a number. No, he wouldn't need it. In fact, when they first started income tax, the collection of it, after the turn of the century, withholding agents didn't have a number. They had no numbers when the withholding agents withheld the tax in the 1860s. They withheld tax in the 1860s, and there was no number. No, it's not needed. It's only needed for the employer. And only then does the employer have to get the number. No, it's voluntary. Making an application of SS4 form is voluntary. Here's an interesting little tidbit that kind of goes along with this. This is a letter sent back to one of our members who forwarded it on to us. And what he did was he wrote to the Library of Congress and asked them about zip codes because some patriot groups around the country were contending for some time, I guess some may still do, that if you use a zip code, it puts you in some kind of a jurisdiction that gives you an obligation and a duty to pay an income tax. Now, I don't know where that comes from. I think it's ludicrous myself. And so this fellow, he wanted to settle it, so he wrote to the Library of Congress and he asked them. And this letter says, "This is a letter in response to your request for information concerning the legal significance of the zip codes. The United States Postal Service handles over 147 billion pieces of mail each year." A lot of mail, isn't it? I just received a pleading, it was yesterday. I received a pleading from my opponent, Jonathan Jackal, from the Department of Justice, and he was complaining in his brief to the judge that I make hundreds and hundreds of Privacy Act requests every year. So I guess we contribute a lot to this 147 billion. As far as we can determine, the zip codes were developed to facilitate the speed and accuracy in handling the mail in order to provide better service. I am not sure what the zip code have to do with jurisdiction, except to pinpoint a particular area of the country. Like paying taxes, using zip codes is voluntary. Huh? He's from Assistant Chief in the Library of Congress. I mean, the law library, American British and what's that? Law Division. I couldn't make it A. British Law Division, American and British Law Division, Library of Congress, Assistant Chief, is telling us that it's voluntary, and it would not be illegal not to use them. So he takes the word voluntary beyond the definition the IRS gives to the word voluntary. Anybody know what the IRS usually responds to when they talk about voluntary? Huh? What do they usually say? They call the IRS up and say, "Is the filing of a tax return voluntary or compulsory?" Well, it's voluntary. Fine, I don't want to volunteer this year. Oh, you have to. And you'll go in a circle from there on, a never-ending circle. But if they'll correspond to you from Washington, D.C., they'll say, well, it's voluntary, like stopping at a stoplight is voluntary. You see? So that's the connotation they give you. You know, it's the same way they talk to you. A politician or a lawyer will talk to you about a new law they want to push. Well, they'll say, you know, you cannot holler fire in a crowded theater. And they take everything and put it in that context. So then, under such a principle as that, you can make any law you want. You can excuse any law you want, you say, and go forward with it. All right. However, the result is not using zip codes would probably be a 3-day delay on the delivery of one's mail. If you have additional questions, you should direct them to the information office, regional post office, etc. So we appreciate that little tidbit from the Library of Congress. Now,
John, have you ever received any mail from, well, I'm quite sure you have, you know, where people don't use zip code numbers, they just use
right.
non-domestic or something like that?
Yeah, right.
I mean, what is
we get it all the time. It arrives a little late.
I mean, but is there a purpose for that?
Well, see, some of these people believe that by using the zip code, it's causing a requirement to pay a tax. What we have, you know, law is a vast subject. I mean, you know, you can study all your life about law and still not know everything. I mean, anybody. That's why lawyers specialize in things. And particularly if you get a layman. And when you have a movement like we have today, you get people who become aware of something, right? And all of a sudden it's like a new convert, you know. They want to see everything and anything. And what happens is that they read something, and not having very little knowledge about law, They jump to conclusions. And the second thing they want to do, nobody wants to recognize or admit that their government is doing something that's wrong. They want everything to be peaceful and calm and roses, you see. So they try to find some excuse why the government's doing these things. And they come up with such things as that. And of course, you know, I think we got into this a while back, if I remember, where we showed you it's Section 7701A39, talking about zip codes. Well, not zip codes, really. It talks about the jurisdiction when you're out of the state of the Union. And it's the rationale that this fellow who started this stuff about the zip code, who lives out in the state of Washington, used. In 7701A39, it says that when you're outside of a state of the Union, the jurisdiction for any legal action would be in the District of Columbia. So right away he jumps to a conclusion that that's regional government, and the zip codes are used in regions, and therefore under that jurisdiction you owe a tax if you use a zip code. That's how he come up with that. I mean, it's so far out that when I first saw it, I laughed. But it's really not a laughing matter, because a lot of people read that stuff and they write it in such a way that it sounds convincing, and they fall for that type of thing because they want to excuse their government. They want to find some reason why. They just don't want to face the fact that a court can violate the law in ruling against you and that there's no justice. Some people don't want to face the truth. You know, in this country, it was reported, I understand on the BBC, if I'm correct, that this country has dropped to 13th as far as deprivation of human rights in the world. And it's worse than China. China's around 12 or 11, I believe. But it wasn't reported in our press. But we're now below China as far as deprivation of human rights. I think that's pretty bad. And it's getting worse. And we've got to face up to the fact that we have Americans who can actually abuse other Americans. And they're doing it daily. I mean, if Waco and Weaver out in Idaho didn't show you that, then you won't see anything. So anyway, well, let's get on to Chapter 78 of the Internal Revenue Code, which deals with discovery of liability and enforcement of title. So this is the authority for the Internal Revenue Service employees to have discovery of liability, and also their authority under the title, how it's expressed. Notice in subchapter A, it says examination and inspection. In 7601, section 7601, it talks about canvass of districts for taxable persons and objects. See down here, that would be 7601. General rule, the secretary shall, to the extent he deems it practicable, cause officers or employees of the Treasury Department to proceed from time to time through each Internal Revenue District and inquire after and concerning all persons therein who may be liable to pay any Internal Revenue tax, and all persons owning or having the care and management of any object with respect to which any tax is imposed. So this gives them the authority to go out and look for people who owe taxes, right? Now, what we want to show you is Section 7608, authority of the Internal Revenue Enforcement Officers. Now, this tells you the authority that the officers have. Look at this carefully. Enforcement of Subtitle E and other laws pertaining to liquor, tobacco, and firearms. Any investigator, agent, or other Internal Revenue officer, by whatever term designated, whom the Secretary charges with the duty of enforcing any of the criminal, seizure, or forfeiture provisions of Subtitle E or of any other law of the United States pertaining to the commodities subject to tax under such subtitle, for the enforcement of which the Secretary is responsible, may carry forms, etc. So we see that revenue officers and the like have authority under what? Subtitle E. And Subtitle E is what? Alcohol, tobacco, farms, and other certain excise taxes, right? That's the title of Subtitle E. Now that's A. Let's drop down to B of Section 7608. B, enforcement of laws relating to internal revenue other than Subtitle E. 1. Any criminal investigator of the Intelligence Division or of the Internal Security Division of the Internal Revenue Service, whom the Secretary charges with the duty of enforcing any of the criminal provisions of the Internal Revenue laws, any other criminal provisions of law relating to internal revenue for the enforcement of which the Secretary is responsible, in the performance of his duties authorized to perform the functions described in paragraph 2. And he may do all these things. But notice, who investigates other than Subtitle E? Criminal investigators. Who are the criminal investigators? They're called special agents. They do all the criminal investigation. Now, a revenue officer handles all the civil matters, right? And what authority does he have? What authority does he have?
You say criminal investigator?
A revenue officer? A revenue officer is not a criminal investigator. He's the one,
Right.
A revenue officer, a revenue agent, they'll do audits and they'll come down and let me see your books, I want to examine your books. But a criminal investigator, the only thing he does is investigate you to charge you with a criminal offense. Now, who has authority other than Subtitle E? What's other than Subtitle E? What does that mean?
Everything else.
Other taxes.
The other what?
Other taxes.
The other taxes?
The other subtitles.
The other subtitles. So what are they?
A, B,
We have A, which is income.
B,
B, estate and gift.
C,
C, employment.
D.
D, miscellaneous excise. And then you have E, alcohol, tobacco, and other certain excise taxes.
That's up on A.
That's A. So what you have is revenue officers and revenue agents have authority to investigate liquor, tobacco, and firearms, and criminal investigators are all the other subtitles. What does that tell you?
Income and employment taxes are excluded.
Are excluded from what? Revenue officers and revenue agents to enforce. Is that correct?
Yes. Correct.
All right. So that means that other than Subtitle E, which is all the other ones, criminal investigators. And what have we found so far is the application of the other subtitles. Subtitle A is who? Who is the subject of Subtitle A?
Withholding agent.
The withholding agent has the liability. All right, who does...
Well, the subject is the non-resident alien.
Non-resident alien, foreign corporation, foreign tax exempt organization within the states of the Union. All right, who else?
Citizens abroad.
Citizens and resident aliens abroad. Only abroad? Just abroad? Just abroad? Any place abroad it's a citizen or a resident alien?
No.
Tax treaty.
abroad under a tax treaty. So in other words, they have to be abroad in a foreign country where there's a tax treaty. Right? All right? So that is subtitle A. Now, subtitle B is state and gift tax. Well, my research of it, for whatever that's worth, has found that it applies to the federal states. All right? What are the federal states?
Puerto Rico.
The possessions and territories are federal states. That's been mine. I can't find anything else. I would love for somebody to show me other than that, other than federal states. Now that takes us to subtitle C. What about subtitle C now? What's the application of subtitle C? Employment taxes, right? So that means employees, employers, wages, right? So what is all that? That's all Social Security. And is it imposed by law? It's voluntary. All right, that takes us down to D. All right, now D is special excise taxes, temporary excise taxes. So the criminal investigators enforce all that. Can anybody recall just a few hours ago when we showed you the authority that we have found for criminal investigators? Anybody recall that?
Non-resident aliens and citizens or resident aliens working overseas.
Yeah, we found there was, where did we find that at? Anybody recall where we found that at? In the Internal Revenue Manual, where at? Chapter 1100, Organization and Staffing. Organization and staffing tells you the organization of the IRS, how it's structured, and their staffing and what duties each branch and division have, and the employees within those branches and divisions. And we found in section 1132.75 that the authority of a criminal investigator is to investigate United States citizens and resident aliens living abroad and foreigners doing business in the United States. Remember that? So what does that say about all these other subtitles then, other than E, that we just had? Sorry.
They don't apply to U.S. citizens.
Evidently. Evidently. All right, now we're going to go through the parallel table of authorities. Remember the parallel table of authorities? From the regulations, index of the regulations. And we're going to look up some of these code sections we've been talking about here tonight. When we come down here, let's first talk about section 6020. Remember 6020? Remember what that was? Anybody recall section 6020?
Substitute for return?
Well, it's the authority for the secretary to file a return for someone who fails to do so. Don't you recall the code section showed that the secretary has a requirement. It's not elective on his part. He has a requirement to file a return for everyone who has a requirement to do so anywhere within the code when they fail to do so, or when they file a false or fraudulent return. Remember that? Now the question is, if the individual is charged with failure to file, what should the secretary be charged with if there was no return made by him?
Requirement to do it.
Failure to file. I think that's one of the first things that should be done. If somebody's charged with failure to file, then they ought to file a cross-complaint that the secretary's charged along with them, because he has a requirement under the law. The requirement for an individual is vague, as we all know. And as I asked the judge, I said, well, that's foreign earned income. And he says, I disagree with that. I said, well, what about Part 602 of the regs? And he refused to answer. He marched out of the courtroom in a huff. 602 of the regs shows very clearly that Section 6012 requirement to file only is the foreign earned income. Of course, they don't want to talk about that. But here we have Section 6020. And then we cross-reference 6020. And what does it say? 27 Part 70. Anybody know what that means, 27 Part 70? Title 27, Part 70 of the regs. What's Title 27?
Alcohol, tobacco, and firearms.
Alcohol, tobacco, and firearms. So the authority for the Secretary to file a return for those who have a requirement to do so involves what? Subtitle E, alcohol, tobacco, and firearms. So the only requirement would be what? Subtitle E, alcohol, tobacco, and firearms. That's your cross-reference. What other conclusion could you draw? It doesn't say anything about Title 26, does it? No, because it says, if you'll recall, that he is to make this return from what? His own knowledge. Well, would he have any knowledge of your business? Hey, how can he make a return? Do they know everybody's business in the country? Of course not. But could he make a return from his own knowledge for a person who is manufacturing or selling alcohol, tobacco, or foreign products? He would have knowledge of. How would he have knowledge of that?
From the still.
From rating his still, huh?
What I mean with the distillery, with their records of it.
From stamps.
Yeah.
It's a stamp tax.
Right.
So they know how many stamps they use, unless they're counterfeiting stamps. Of course, that's another offense, but they know exactly what the tax is. Now does the code section make more sense? Right? So we see that little tidbit. Now we're going to have another little tidbit from the parallel tables. It goes along with Chapter 78, Enforcement of the Title, which we have here. And it goes to Section 7601 through 7606. And what does it say? Title what? 27. So all the enforcement of the title down through here is Title 27, alcohol, tobacco, and firearms. That makes sense when you go back in. Let's go to 7608. Remember 7608, which we went into? Revenue officers have subtitle E, and criminal investigators all other than but subtitle E. Look what it says. Title 27. Part 70, 170, and 296. So we see even when we cross-reference it, it all comes out to what? The application of the code is either an excise tax, which is indirect tax through participation in manufacturing, or it's a foreign tax. Right? It keeps, all the time, it keeps checking back and forth and shows you the same thing over and over again. Now what we have here is a little tidbit that I dug out of our CD. We have our manual on a CD-ROM in our computers, and I dug this out from that. This is subsection 4585.1, assessment procedures. I thought there were some things in here that might interest you. Remember the section of the code that assesses the tax. What section is it? Anybody remember?
Which tax? 1461? 1460?
No, the general provisions under subtitle F.
Oh.
Right? There's a code section that assesses tax under subtitle F. General provisions. It's section 6201. That's tax assessment. Now what we have here is regulation 301, and part 301 of the regs is administration and procedures. Whenever you see 301, that's what that means, administration and procedures. And here it has 301, 6201, authorizes assessments by district directors and service center directors. In certain situations, it may be advisable to assess the tax in the district office. Such procedure will be coordinated with the appropriate service center. However, assessment may be made by telephone call to the service center. We come down here. Computer Services and Accounting Division. The following information should be submitted in all cases to the extent practicable. Of course, we did the highlight on there, so that's why I put the Emphasis added here. Now we'll drop down to here and go on, and it says, the service center will process the assessment and notify the district of the document locator number and form what? Remember 23C, that's the certificate of assessment, right? It's assigned by who? Who's the certificate of assessment signed by?
Chief of the accounting branch.
Chief of the accounting branch, right. That's how an assessment occurs, by the chief of the accounting branch signing a 23C certificate of assessment. This information will be placed on Form 2644. Form 2644 and attachments will be forwarded promptly to the service center using special handling. Notice Form 3198. Noted telephone assessment. And then it comes on down talking about termination, assessment of income tax under special handling, check process, etc. It takes us over to the next page. To prevent premature processing of any document filed by the taxpayer, the Chief Examination Division will request control over the master file. What is the master file?
Each individual file or each person.
Yeah, but what is a master file?
It's a
Computer file. That's a computer file. A master file is a computer file. Okay. A non-master file is an actual hard copy document file. But a master file is the computer file. So if it's an individual, it would be an individual master file. If it's a business, it would be a business master file, right? But it's a computer file. Through the use of transaction code TC 914. Now we're going to get into this a little bit. A 914 is decoded in a 6209 decoding handbook as an initiation of a criminal investigation. But in this instance, they're using this for an assessment purpose, which we found very interesting. It caught my eye and was one of the reasons why I brought this out. The top portion of Form 4135, Criminal Investigation Control Notice, original and 3 copies submitted for the signature of Chief Criminal Investigation Division, will initiate the control. The remarks section of 4135 will contain the following instructions. This is a termination assessment of income tax. Do not post full year return. Send any returns received to Chief Examination Branch, Office of Compliance, Assistant Commissioner, Assistant Commissioner what? International. You say it? Huh? One more piece of evidence that it's what? A foreign tax. Right? And it's a general provision. So what we have, this here, you say, oh, that might be old hat. Well, no. It says copyrighted 1994 Commerce Clearinghouse. Huh? Everybody understand? So it's dealing with an income tax, and whose office handles income tax? Assistant Commissioner International. Okay, now we'll go forward. Persons claiming not to be subject to withholding of income tax. This is called Publication 515. Now, if you would go down to the IRS some years ago, maybe 6 or 7 years ago, or maybe a little longer, you could go down to the Internal Revenue Service, and this would be in the rack down there in the lobby. You go down there now, it's not there. And if you request it, they'll tell you they don't have it. And it might take you a Privacy Act request, or a Freedom of Information Act request, rather, to obtain one. They don't want to give them out anymore.
They're becoming harder.
They're becoming harder and harder to get a hold of, and all over the place, even in libraries. If you had no knowledge of what we're talking about here, and you would pass by that rack, and you would read the title of this publication, 515, Withholding of Tax on Non-Resident Aliens and Foreign Corporations. You wouldn't even pick it up, would you? You thought it would have nothing to do with me. Why should I read that? I have enough to read already, right? But let's kind of look at the publication. Introduction. Who is this talking to? Who's it talking to?
Employer.
Withholding agents. It's a publication for withholding agents. See it? Withholding of tax on non-resident foreign corporations and aliens, right? So it's a publication for the withholding agent. Look what it says. If you control or are responsible for the receipt, disposal, custody, or payment of the items of income discussed in this publication, you must withhold income tax on them. If you are required to withhold the tax, you become the
Taxpayer.
liable for its payment. So, who's the taxpayer in the code?
Withholding agent.
And what subtitle? Who's the taxpayer in subtitle E?
Manufacturer.
The manufacturer of the alcohol, tobacco, or foreign products. Right? Who's the taxpayer in subtitle C?
Where we decide to join.
No. Who's the taxpayer in subtitle C?
The employer.
The employer. Even though it's voluntary, some of them are still collecting the tax and they become the taxpayer. They're paying it, right? So we got to understand these things. Who are the taxpayers? People say I'm a taxpayer. You hear it all the time. Now, what you have to understand, there's two types of taxpayers. There's a tax, payer, right, who pays property taxes, sales taxes, and the like. And there's a tax, payer, one word. One has two words and one has one word. Now you say, well, that's being pretty piffy and picky. No. Remember, we went into this, that legal terms have to be defined. Right? All legal terms in taxpayer, one word, is a legal term within the Internal Revenue Code. Anybody know? It's at 7701A14. Anybody know what it says? What is a taxpayer according to 7701A14? Anyone having a liability within this title. A taxpayer is anyone having a liability within this title. So that's the whole title. So if you call yourself a taxpayer, and evidently, what do you have? Within the Internal Revenue Code, particularly if you use one word. You have a liability by admission. Then if you do that, the IRS can what? Remember the type of law I told you about a little while ago. The IRS can what when you call yourself a taxpayer?
Assess?
No. When they write you, they say, "Dear taxpayer." Right? So if you call yourself that, what can the IRS do? They can presume that you are that. And under the law of presumption, they can go forward until that's rebutted. Everybody understand that? The law of presumption, it can be presumed that is a fact unless it's rebutted. And you know, law is words. That's what law is. It's all words. And all the words have to be defined. So you cannot use them loose like you do in normal conversation. Every word means something. All right? So we see who the taxpayer is. Now, let's go over to the next page in this publication, 515. I blew this up for your convenience. It talks about withholding exemptions and reductions. Down here in the second paragraph, evidence of resident. If an individual gives you, the withholding agent, a written statement in duplicate stating that he or she is a citizen or resident of the United States and you do not know otherwise, you may accept this statement and are relieved from the duty of withholding the tax. Now, most people would walk right on by that publication and not even look at it because of its title. See what it says? Now, for some time, some of our members have been giving withholding agents or potential withholding agents or anyone who would withhold from them. That could be anybody. If I'm building a house and the owner that I'm building for, the property owner I'm building the house for, if they're paying me, they're a potential withholding agent. So if I give them a statement of citizenship in duplicate, they have to follow this, which is what happens is, according to the law, which I'm going to show you in a minute, they keep the original and send the duplicate to the Internal Revenue Service. Now, some of our members have been doing this, and other people have been doing this, because that's what the law says to do. We want to obey the law as it's written. Right? I mean, that's what we asked all the judges. Are you going to apply the law as it's written by Congress? Because when we examine the law written by Congress, it favors the citizens, which it should. Somehow in the translation, which we like to think of as sophistry of the courts, it gets a little twisted and changed. We just had one of our members call up, I think it was like Wednesday, and this member told me that he was in business for himself, but now he's going to work for someone else, and he's in computer services. And what he told me was that he explained to these people he's going to work for, he knows them intimately, that he was going to give them a statement of citizenship. Well, you know, people, all these years, these people who have employed people know that they have to get W-4s. They know they have to withhold this stuff. They have to have a Social Security number. I mean, that's the way it is in practice. But everyone who's doing this, if you would go up and ask them about the law, none of them could tell you anything about the law. In fact, we talk to them all the time because of our members giving them statements of citizenship. And when we say, so let's talk about the law, they pull out what is called a circular E. And that's their extent of knowledge about law, some kind of a circular E. It tells them how much to withhold for certain amounts. But anyway, so this member told me that he told them that why don't we call the Internal Revenue Service together and I will take your part and say that I'm employing you. I'll be you. So they agreed to that. And he called the Philadelphia Service Center. And he got a division called Tax Tech 5. And he talked to a Mr. Hall. And Mr. Hall, he told Mr. Hall that he's hiring this individual on, and the individual claims he does not have any Social Security number, and he wants to give me a statement of citizenship. Should I accept this? And Mr. Hall says that's perfectly all right to accept it. He says you have to accept it in duplicate. You keep the original and send the duplicate to the service center director, and then you do not withhold from him. He said at the end of the year, what you do at the end of the year, you will send in a W-2 form. And you would write on a W-2 form that you did not withhold throughout the year. And where the Social Security number is, the space for that, you would put all zeros in. Well, that was the reason that the member was calling me up, because he was leery about sending in the W-2, and he wanted to find out about that. And I said, well, there's nothing wrong sending a W-2 in if the person is an employer with an EIN number, because they're supposed to send in W-2s. That's the law. They're required to. The only thing that I would say, if it was me, I would never put zeros in the spaces for the number, because zero is a number. And what could happen if you put zeros in the spaces, they could contend that you're using a wrong Social Security number and send that in order to back up withhold. and take 30% of everything you make. And you'd be a month of Sundays trying to straighten it out. What I would do instead of that, I would write the word none in there, which could not be taken for a number, and it's very explicit. And he said, well, thank you, I think we will do that. So I wanted to tell you that little story before I showed you the law. Now here's the law. It's a regulation, and it's found in Part 1 of the regs. And it's 1.1441-5. And it says, claiming to be a person not subject to withholding. And it says, individuals, for the purpose of Chapter 3 of the Code. Well, that doesn't pertain. How many chapters are in Subtitle A, income tax? Does anybody remember?
6.
That's right. He's getting good in this room. I mean, we're really picking this stuff up. 6 chapters. Bruce, you're right on the ball. Okay. Well, why doesn't it say chapter 1, 2, 4, 5, or 6? Why just 3?
The place where a requirement to withhold is found.
There is no other withholding within the chapters except chapter 3. You can't find any withholding except chapter 3, right? And it's only 4 sections within chapter 3 that authorizes the withholding of income tax. Out of all subtitle A, that's the only chapter, there's 4 sections. So that's why it says chapter 3 of the Code. It could say the same thing. It could say subtitle A, or it could say income tax in this title, and still be the same. It would still be in chapter 3. The individual's written statement that he or she is a citizen or resident of the United States may be relied upon by the payer. Who's the payer?
Employee.
Who's the payer?
Employee.
Withholding agent. He's the one who's paying, right? He withholds and pays it, so he's the payer. How many payers are there in the Code? How many payers are there in the Code?
3.
There's one in subtitle A, one in subtitle C, and subtitle D and E. Right? Now we ought to qualify that. How many payers are there dealing with individuals? How many payers are there in the Code dealing with individuals? 2. Right? There's only 2 payers, the employer and the withholding agent. Right? Okay. By the payer of the income, so we're talking about income tax, right? As proof of such individual as a citizen or resident of the United States. Then it goes on over here in the next column to say, disposition of statement and form. The duplicate copy of each statement and form filed pursuant to this section shall be forwarded with a letter of transmittal to the Internal Revenue Service Center, Philadelphia, Pennsylvania. The original statement shall be retained by the withholding agent. Well, suppose you live in Seattle, Washington. What's the service center for Seattle, Washington? Anybody know? Maybe it's a little too much there. What's the service center for Seattle, Washington? Ogden, Utah. Who said Ogden? Bob? Good. Ogden, Utah. That's correct. Well, would somebody in Seattle, Washington, would the withholding agent in Seattle, Washington, send a statement of citizenship to Ogden, Utah? The reg says it goes where? To Philadelphia. It doesn't matter if you live in Seattle, San Diego, Phoenix, Arizona, or wherever, Timbuktu, or Podunk, Idaho. It goes to Philadelphia. Why is that? Philadelphia is the International Service Center. All right, designated as such. And Baltimore is designated as the International District Office. Okay? That's why it goes there. So everybody understands that, right? So when it comes to withholding of income tax, they tell you how a citizen gets out of it. So what does that mean about citizens? What is the application of the code involving citizens within the states of the Union. Well, there is some. What is it? What is the application of the Internal Revenue Code as far as citizens within the states of the Union? Voluntary compliance and self-assessment.
In this tape, we emphasize that there is no law that actually requires employment taxes to be withheld from U.S. citizens who live and work within the 50 states. Such laws cannot and do not exist because the Constitution protects private property. Thus, any form of progressive taxation would be unconstitutional because the progressive taxation of wages is actually a redistribution of wealth. We pointed out, however, that the tax on wages circumvents the Constitution because the subject of the tax in Subtitle C is the wage of the applicant who has voluntarily entered into an agreement. Remember, Subtitle C pertains only to those who apply to participate in the Social Security Entitlement Program. To clarify how the employment tax laws are applied, we explained that, under the law, a business is not obligated to collect employment taxes until an application is made to become an employer and an employee with a Social Security number submits a W-4 signifying willingness to participate. The actual legal requirements in Subtitle C are therefore dependent on applications that are entirely voluntary. If any one of these conditions is not met, then the employee is not a covered employee, and money earned is not a wage as defined by the law. Furthermore, unless and until these conditions exist, the money received by this employee is not taxable. That's why, without a signed W-4 from an employer cannot legally withhold Social Security taxes. Employers and accountants are becoming increasingly aware of these limitations because people are revoking their application for Social Security benefits in record numbers. This in turn calls attention to the limited aspects of the law because a person who does not have a Social Security number cannot fill out a W-4. And yes, the employer is required to give a W-4 to an employee. However, the employee is not compelled by law to either fill out the W-4, submit it, or participate in any way. In fact, according to the law, an employee may submit a statement of citizenship to relieve the employer of his duty to withhold the tax. According to Section 1.1441 through 5 of the regulations, the employer fulfills his legal obligation when he forwards a copy of the Statement of Citizenship to the International IRS Service Center in Philadelphia. However, to use the IRS's own expression, not all employers understand the nature of the tax situation, and some, acting on the advice of misinformed accountants and lawyers, have improperly withheld money from such employees in violation of law. Specifically, an employer who deducts taxes from his employee's paycheck without a properly executed W-4 is guilty of the crime of conversion. Conversion is the act of taking a person's property and giving it to another for unauthorized use. This usually occurs because of ignorance, but it is an ignorance that is perpetrated by the bureaucracy within the IRS, a bureaucracy that is not concerned with accountability. For example, the IRS deliberately steers accountants and attorneys away from the law. But at the same time, the IRS directs the attention of tax professionals to pamphlets that they publish. These pamphlets, of course, are written to maintain a very narrow focus. With respect to employment taxes, for example, the legal requirements outlined in the pamphlets assume that the parties are all applicants. They contain no reference to provisions of law that would pertain to, for example, individuals without Social Security numbers or businesses that have not applied for the privilege of acting as an employer. Besides these carefully written pamphlets, the IRS holds workshops for accountants and lawyers to explain what is expected from applicants. But the IRS conveniently assumes that everyone has applied or wants to apply. What most accountants and attorneys don't realize is that these workshops never explain the limited nature of the law and that people are not required to participate, unless, of course, they want the benefits. And The IRS does not explain what must be done when non-applicants are involved, because the mission of the IRS is to achieve the highest level of voluntary compliance, and a complete explanation of how the tax system works would defeat this purpose. We emphasize that a thorough explanation should include an overview of the structure of the code and a review of the limited application of its various subtitles. For example, IRS workshops should explain that the tax that is known as income tax is in Subtitle A, and the income tax in Subtitle A is imposed by law, but the income tax is only imposed on the income of foreigners, or the foreign earned income of U.S. citizens. In contrast, the tax that is known as employment tax is in Subtitle C. But, unlike the income tax, the employment tax is not imposed by law, because the legal requirements for employment tax apply only to applicants who participate voluntarily. For example, employers are required to report what they deduct, but no one is required to be an employer. And the employer must give a W-4 to every employee, but the employee is not required to fill it out or return it. According to many authorities, the Internal Revenue Code is an enigma. Even former IRS Commissioner Shirley Peterson admits that it is incomprehensible and that accountants, lawyers, and other tax professionals don't understand it. But what she doesn't say is that the reason people can't understand the code is that these details are never explained. These details are important if the public is to obey the law. If the IRS is unwilling to supply accurate and complete information, then the public may be subject to misinformation from unreliable sources. We gave an example of this when we explained that some partially informed activists are telling people to file exempt W-4s to claim exemption from income tax. However, according to the law, only students can claim exempt on a W-4. Others who claim exempt are actually committing tax fraud. Remember, the proper method for a U.S. citizen to claim exemption from income tax is to submit a statement of citizenship. We then summarize several aspects of employment tax to emphasize that the employment tax in Subtitle C is Social Security, and that the wages of covered employees are subject to employment taxes for the purpose of building credits toward Social Security benefits. That's why the Social Security number is the tax ID number, and why a person without a Social Security number has no taxable wages. We also talked about self-employment and explained that self-employment is a term that pertains to individuals who are both employer and employee simultaneously. We pointed out that self-employment taxes are imposed with income tax in Subtitle A. However, we also showed that, according to Section 1401, the self-employment tax is imposed with the taxes in Sections 1 and 3. Of course, Chapter 1 contains the provisions for the tax on foreign earned income, and Chapter 3 contains the provisions for the tax on the income of foreign persons. Remember, Chapters 1 and 3 contain provisions for taxes that arise from tax treaties with certain foreign countries. There is absolutely no provision within these sections that would apply to the self-employment income of citizens living and working within the 50 states. In this tape, we also related the limitations of the laws pertaining to investigations and showed that Section 7608 of the Internal Revenue Code gives investigative authority to Internal Revenue Enforcement officers. However, we also showed that the authority of revenue officers is limited to the enforcement of Subtitle E, which contains the provisions pertaining to alcohol, tobacco, and firearms, not income tax, and that the enforcement authority for all other subtitles, including income tax, is limited to criminal investigators of the Intelligence Division or of the Internal Security Division. In other words, letters that are sent out by ordinary IRS revenue officers to investigate liabilities related to 1040 income tax returns are sent without any legal authority. While we were on the subject of filing requirements, we examined the legal obligations for individuals and showed that individual filing requirements are vague, unlike the Secretary's filing requirement in Section 6020. You'll recall that the Secretary must execute and sign a return for any taxpayer who fails to file, and that in such cases, the IRS usually fakes the execution of a 1040. But sometimes, in an apparent contradiction to the law, the IRS will ignore the requirement in Section 6020 and, instead of filing the fake 1040 as we previously outlined, the Secretary will charge the individual with willful failure to file. We drew attention to this arbitrary violation to emphasize that the IRS's misapplication of law was not consistent. And, to drive the point home, we suggested that if the Secretary ignored his requirement to file, then the Secretary should be charged with willful failure to file. But the fact is, as we have already shown, the 1040 is not a required return. And the income of U.S. citizens living and working within the 50 states is not the subject of the income tax under Subtitle A. If it were, then we would expect to find a requirement to withhold income tax from U.S. citizens. To the contrary, the IRS actually instructs withholding agents to pay U.S. citizens without deduction. Publication 515 tells withholding agents they are relieved from the duty of withholding the income tax when they receive a statement of citizenship from a U.S. citizen. After presenting these instructions and explaining the proper method for U.S. citizens to claim their lawful exemption under the law, we mentioned once again that there are two kinds of taxpayers. There are taxpayers and there are taxpayers. The first term is a plain English expression, and it refers to anyone who pays any kind of tax. If you've ever paid a sales tax at the cash register or a property tax, then you're a taxpayer in the ordinary plain English sense of the word. However, the second term is a legal definition. It is one word, not two, and it is not a plain English expression. The term taxpayer is defined in Section 7701A14. Specifically, a taxpayer is someone who is subject to an internal revenue tax. And finally, we offered a brief historical explanation as to why the tax laws seem so convoluted and difficult to understand. We explained that during World War II, Congress enacted the victory tax, which was a tax on the income of U.S. citizens. And, as you might suspect, the victory tax was unconstitutional. However, no one challenged it, because, after all, who would challenge a victory tax during a time of war? When the war was over, there were certain people who wanted to continue taxing the income of citizens. So, the victory tax on income was changed to a tax on wages, and Subtitle C became the repository for the provisions pertaining to the new tax. Of course, Subtitle C was never imposed, and by virtue of its voluntary nature, it was not unconstitutional. However, conveniently enough, the title of the new law was Income Tax, Collected at Source on Wages, implying, of course, that an income tax was being collected from citizens, when in fact it was not. Section 7806 of the Internal Revenue Code clearly states, titles have no legal effect. But the illusion was well painted, and the sophistry used by a few determined government officials continues to this day, confounding even IRS officials who were never taught the history of the law or the limited application that was part of its legislative intent. If we are to remain a free country, then we must understand that freedom requires responsibility. Without responsibility, especially the responsibility of keeping our government in check, we subject ourselves to greed, lawlessness, and thievery, and we leave this legacy to our children.